Hi, I'm Frank Gitson. I'm here to talk to you about premise liability cases. Those are cases when you have gone on someone else's property and got hurt. They're called premise liability cases. And it all comes down to the status of you as an individual. So the first type of person that we have in the state of Florida is a trespasser. You're not supposed to be on the property, you don't have authority to be on the property. The landowner owes you really a no duty except not to have some dangerous device. They call them a spring gun in law school, where if you open the door, there's a shotgun there and it shoots you. The value of life is more than the rights of your property rights, so therefore that's the only thing we need to make sure you don't have if you're trying to protect yourself from a trespasser. The second one is a social invitee, and I invite you to come over to my house and watch the Super Bowl. Unfortunately, we're getting up into a deck or a dock, and there's termites in there. I should have inspected the property on a regular basis to make sure that it's safe. For instance, a root that is pushing up the sidewalk coming into my house, it takes a long time to get that up, and the postman comes and trips over it. Then I'm responsible and I have liability, and therefore my homeowner's policy would pay you as a social invitee if I did not inspect my property fairly regularly. The one everybody calls about is a premise liability against a large store, Walmart, Publix, something like that. As a business owner, you're coming in as a business invitee, and therefore I'm trying to take money from you, sell you something along those lines. So as a landowner and a business owner, you have to inspect the property frequently. If you're in Walmart, you'll hear it says aisle associates do your walkthroughs. They have them walk up and down the aisles every 20 minutes and say they were clear. There was a long case a long time ago at Winn-Dixie where the mother and the daughter were there. She slipped on a banana peel, I think it was. The manager comes up, looks at the associate and says, "I told you to clean that up 20 minutes ago." Well, that time frame's kind of been put into the law. So as long as they're checking every 20 minutes or so, it is a really tough case to get against them. The only other type of case you could have is if there's some type of defect from a code enforcement. The stairs are not even, they're not up to the Southern Building Code, there's places that aren't lit properly at night. Those can create issues where you can sue the business owner as well. Finally, just like in an auto case, your four damages are any lost wages, your medical bills, your pain and suffering or hurt, loss of enjoyment of life. You can't hunt, fish, water ski, whatever you like to do. Hopefully this helps you with premise liability cases. Visit my website. I got a lot of pages on it, frankgitson.com. And if you think this is helpful, please share it. Thank you for listening.